Welcome back to another episode of the Hearse Chaser podcast show. I'm the host, Stephen McClelland, and we're talking about adult guardianships. Is it help or is it hijack? We get a lot of calls, and I was talking to my staff about what are some things that would be helpful, and this came up, the idea of guardianships, talking about what it is. And of course, I want to talk about my personal philosophy about guardianships, which is I don't want families to go through it. I want it to be a last resort because it is forever. So we're going to talk about, is it really necessary? And if it is, we'll talk about some ways to avoid or make it as best you can. Welcome back to another episode.
You're listening to the Hearse Chaser podcast show. Here's your host, Stephen McClellan.
All right, as we get started, I think sometimes it's helpful to hear a couple stories of situations that I've been involved in, and I remember these because they just are so shocking, so to speak, when it comes to guardianships. And I remember a call I got many years ago from a husband who said he needed guardianship over his wife. And, obviously I always like to ask clients, why do you think you need guardianship? And he said, well, my wife is not doing well. I need to get access to her assets. And I thought, well, why isn't your name already on those assets? And he said, well, it was always kind of kept separate. And I said, well, I'm sure you had a financial advisor that kind of helped you with that account. No, it was all online. I said, well, certainly you've got a power of attorney. He said, no, we didn't do that. And so we ended up needing a guardianship so that he had access to those accounts so he could simply pay the bills. And that is common. That is probably 90% of the reasons we need guardianship is so that a family member, not often a spouse, but the children can access those accounts. I've had so many scenarios where the child is really calling and they call frantic because something sudden happened to mom and dad. They have a stroke or a heart attack when they're in their 60s. They never got around to meeting with an attorney or doing any documents. And so what happens is that, well, what can we do? And I said, well, tell me a little bit about mom's condition. She can't write her name. She doesn't know she doesn't know who's around her, is not making good contact. So in those cases, those are, you have to get a guardianship in order to help pay bills and talk to doctors. And I think in some ways guardianships are common because sometimes people do things themselves. When you have a financial advisor, they are so good at saying, hey, I need someone authorized on this account, a trusted individual. And so even if you don't have a power of attorney, that trusted individual can still make decisions. But what often happens is people just wait too late. They don't get around to doing it, and they just get surprised by the fact that maybe they'll need someone to handle things. And there are those who just know they need to. They just don't do it because they don't want to. It's just not fun, or they don't have anyone in the family that they trust, and that makes it harder, makes it easier to delay when you don't trust your family. So the first thing I want to talk about is why guardianships matter. Why do we have them? And you kind of already guessed, it's a situation where someone is unable to make their own medical decisions, or they're unable to handle their finances, and so you need to have a guardianship established for someone with legal authority to do that. And that looks like going in front of a court, in front of a judge. And there are three types of guardianships. There's a temporary guardianship, a permanent guardianship, and an emergency guardianship. I said the last one, which really the last one is really kind of the first. Sometimes there's an emergency guardianship, and I typically don't prefer emergencies because most of the time we can just wait 31 days and get a permanent guardianship, but sometimes there are situations where you have to pay bills immediately, and in those cases you can get in front of a judge faster. These are very important to judges because people need representation. They need someone to look out for their affairs. So in those cases with emergency, let's say somebody needs to pay bills, they have bills due, and if you don't pay them, that's not good, like mortgages and light bills. And so before a judge signs off on it, typically they're going to want a professional evaluation from a doctor. And I can tell you that professional evaluation is sort of all the medical evidence the judge will need. I see some medical evaluations that I don't think match the rules of what Arkansas law requires. Sometimes it's just a letter, and that's actually not appropriate. There's actually a form that we give to the physician to fill out, and most of them are really good about getting that documentation back so that the family can get the guardianship process moved along. But sometimes I've seen the forms that some attorneys submit just not adequate, and the judge says, well, you're kind of missing some requirements here. So the reason you got to think of this from the judge's perspective. They want to make sure that the person truly is incapacitated. And our laws changed a few years ago, and I don't like it. I think whatever well-intentioned our legislators are called, I don't like it. And they changed it, and they said basically the proposed ward, that's that in this case is the adult, is they have to come to court unless they're excused, and I don't like that. It's generally in adult guardianships, and not so. In most guardianships are for children. So 75% of guardianships are for minor kids. That's where mom and dad are unable to handle the affairs, and typically a grandparent or somebody comes in. The ones that come into elder law are more like adult guardianships, which are only 25% of the guardianships that are filed. So when you talk to an attorney about guardianships, we don't do a lot of them simply because there's not a whole lot of them to do in the first place. Okay, so it's not like it's a big part of anyone's practice. Guardianships kind of fall under elder law because often it's an elder law issue there. But so the law changed and said you're going to have to bring mom into court, and we're thinking, a lot of times if there's dementia, they can be very agitated, very angry, and the family's doing everything they can to keep their loved one in a facility, and they're trying to fight to get out. And so I had a situation a number of years ago where the law changed, and we're like, Judge, this person's in the hospital. Like, that's a good reason why they shouldn't be here. And so there's exceptions. Like, you can ask the court for an exception. And then this judge was like, no, I want to see them. It's like, okay, so they're in the hospital, so we had to get somebody to go in the hospital with a camera and FaceTime them with the judge, Zoom them, so the judge could see them. And this was a newer judge in a newer situation and with a new law. And so here's a judge trying to have a conversation with a lady in a hospital bed who has probably not Zoomed much in her life. And so the judge I asked some questions, and the judge asked some questions of the lady, and the lady just cussed out the judge and let him have it. Like, who are you? You awful judge. I think she let him have it and didn't answer any of the questions, and I I just sat back and I thought, this is ridiculous. I mean, I can tell you that this is not, doesn't make sense. And so any guardianship, I mean, even when there's a lot of facilities in Arkansas that take care of children who have special needs, and many of them can't walk, they're on a lot of equipment, and that statute, I mean, you're just bringing them into court. And it's funny, things are in cycles, I think, when it comes to the law. And my partner who practiced years before me, he would tell me that that's how those judges were when he first practiced 30 years before me. And he said they would require the child who's 18 technically to come into court. And it was a huge ordeal to have multiple people come bring them in to court. And finally the judges realized this is not good. This is too much. It's too much stress on them. And so they stopped doing that. And here we are, 20, 30 years, judges, the people who write the laws say, yeah, they need to be there. And I know there was a judge involved in our new guardianship. It changes, and I think, I think maybe just inquiring would be helpful, because in the guardianship process, it is court. So you have to go to court. You have to notice the family, and you have to notice the adult. So you have to have somebody serve, serve the documents and say, hey, you've been summoned. You have this petition against you. And that alone can be extremely troubling to some of the adults.
Thank you for tuning in to the Hearse Chaser podcast show. Our mission is to be your first choice for last wishes. Want to dive deeper? Join us over at the Hearse Chaser Academy, where we've created 8 on-demand courses for each stage of life. From young adulthood to retirement, navigating separation or blended families, and everything in between, we help you plan for the future, no matter where you're at. Now stay with us as the ride continues on the Hearse Chaser podcast show.
And the thing is, we try to minimize that by preparing a time when the family can be there when mom or dad gets served in the home. And so it's not a fun scenario. And I'm reminded of a quote. My grandfather had a quote. It went something like, "If you live long enough, you're once a man and twice a child." And when you see your parents lose their independence, it's very difficult, and it's like having a child all over again. And I can tell my child what's good for them, but a lot of times they don't listen to me. They don't want to do what I say. And it's the same when you're taking care of a parent. They don't think they need certain things. And so if you're in that struggle, you just have to think of it as this is not you, okay? This is just you trying to take care of them, and they don't really know kind of what's good for them. So I'm glad we have a process where we can get somebody in charge to take care of things. That's really the best way to think of the guardianship, as putting somebody in charge. Now, I mentioned in the intro, it's a last resort, okay? The reason I feel that it's a last resort is, in many of the cases where we do adult guardianships, it's because there was no power of attorney, okay? So everybody needs a financial and a healthcare power of attorney, so that when that time comes, if it comes, you have the documents that give your family members the ability to handle your finances and talk to doctors. But statistics show that podcasts like this don't help enough, because people don't do it. Half of Americans don't have an estate plan. And the last statistics I saw, those over 80, 20% don't have an estate plan. So it's very alarming that 1 in 5 older Americans have never put together a power of attorney. And so that delay becomes more costly, because I can tell you it's a lot cheaper to have a good power of attorney than it is to be in guardianship world, right? In front of a judge. And it's I was just thinking. One of my big pet peeves, and when I say last resort, let me tell you what I mean. I think too many attorneys rush into guardianship world. The truth is, attorneys make more money by having a guardianship than doing a power of attorney. But I don't think that's in the best interest of the family. So, for example, if mom or dad can do a power of attorney, I would much rather them do a power of attorney. So here's what happens. A lot of times, I got a call 2 weeks ago. 2 weeks ago, listen, 2 weeks ago, a client came into my office and said, I'm here, I need guardianship over my mom because the doctor said so. And I appreciate what doctors do. I am married to a medical provider. But sometimes I think they're quick themselves to recommend guardianships. So my first thing is to say, well, tell me a little bit more about what you mean that mom or dad needs a guardianship. And, well, they're just having a hard time, and they've just recently been diagnosed with dementia. And, it's just me trying to take care of mom. And I say, wait a second, it's just you. Why do we need to go spend all that money and time doing our guardianship when I can do a power of attorney? Well, the doctor said she had dementia and was incapacitated. And I say, wait a second. I make that determination on the legal documents, not a doctor. Okay? Because there's a very big difference between doctors and lawyers. See, doctors, they'll declare anyone incapacitated at least sooner, partially to protect their license, right? They want to protect their license in order to, they don't want someone to go and do something they shouldn't do. Me as an attorney, I have to give them the benefit of the doubt. And so if I have a situation where it's just one child and it's like, do a power of attorney in my office or go to court, I'm going to do a power of attorney if they meet the certain legal requirements, okay? Now, if they clearly don't know who their kid is, don't understand their assets, and they can't track with me, follow what I'm talking about. No, but there's good days and bad days. And so, if mom happens to have a better morning than afternoon, well, have her come in the morning. And, if the day is sunny, that's probably better than a cloudy, rainy day. So that's very, very important to know that really the attorney is the one that kind of makes that determination. Because guardianships are forever. It's not like people get better and they terminate the guardianship. And so if you are under a guardianship, then the court has control over your assets. What does that mean? Well, if you have a home and you want to sell it, you got to get permission from the court. You got to do annual inventories. You have to tell the court each year why it's necessary to have the guardianship. And I recently found out, a lot of times mom and dad will have investments, right? Wherever. Merrill Lynch, Charles Schwab, Edward Jones, wherever. And I had a financial advisor, their company said, oh, we see someone's under a guardianship. Y'all need to get special permission to continue to invest the money. I didn't realize that. I've been practicing for quite a while, over 10 years, and that's the first time I recall that ever coming up. But sure enough, under our statute, you've got it. You can invest it into bonds and CDs, but if you want to be in something riskier, you have to ask permission from the court. So it's very restrictive on what you can and can't do. If there's fights over powers of attorney, sometimes it's best resolved just to go fight it out in the guardianship court, right? So if I see ping-ponging powers of attorney, it's son this week, daughter next week, and then the third child, in 2 weeks, I'm like, nah, this is enough. Go to court, have the judge appoint somebody. And in our state, the judge is only going to appoint one person. Now, a husband and wife can be co-guardians, but it's only going to be one person, which is not good, because a lot of times when I do a power of attorney, I'll have multiple kids on the power of attorney because they all have to work together to get things done. But if under a guardianship, I'm only stuck with one. And it's important to know that a guardianship has finance and healthcare. So, you could have a daughter that's a healthcare guardian and over the person, and the estate is the son. But generally speaking, it's just a mess because the court's making that determination, and that's not fun. And now you can name who you want to be your guardian in your documents if it comes to that. The judge is typically going to say, well, if mom or dad said this child is the power of attorney, I'm probably going to go with him. But you might want to update that. I think it's important to update that when it comes to who you want to serve. But I can't emphasize enough the importance of having the power of attorney in the first place, because it resolves a lot of issues. And just make sure you have a good reason even to have a guardianship. Sometimes the facility, like if mom or dad's in assisted living or a nursing home, they may require a guardianship. That can happen. They just want the right authority to make sure they're talking to the right people. But every situation is a little different. It's just best, I think, to have a plan where your assets are not open to the public under a guardianship, where you choose who you want. And the best thing is that it puts a plan in place so you are not being hijacked. Because capacity is a thing that there are good days and bad days. And truth is, probably we all act some days needing a guardianship because we all act like, who are we? But when it comes to a guardianship, whether you have good days or bad days, you're judged based on your worst day. So the doctor's going to say, yeah, you need a guardianship. But maybe you don't need it all the time. Or maybe there's a lot of gray area. And that's where I think the power of attorney does a better job, because it recognizes that people have good days and they have bad days. And I don't have to have a guardianship, the court involved in every day of someone's life. So if you're watching this video, likely you are a child or a friend of someone that might need an adult guardianship. It is something that is a great tool if you have nothing available. But if there's any way to avoid it, try to find a second option. And thanks for riding along today with the Hearse Chaser podcast show. And we hope to see you on our next ride.
Hey, thanks for listening to the Hearse Chaser podcast show. Please remember, you can't outrun a hearse, but you can leave your family with a smooth ride.